Well, welcome everybody. We're going to give it a few minutes for some more folks to join in. We had a lot of interest in this topic, as you might imagine. So thank you for joining us. I'm Brian Calley, CEO of the Small Business Association of Michigan, and we will get started here in probably about another minute. If you're just joining us, we will get started in just under a minute here. All right, as folks are still filtering in, I see we've got 100 online already, and we had several more that I think will be joining, looking at registrations, but I want to respect everybody's time. There's a lot of material to cover. So we're going to go ahead and get rolling as people start to filter in. So I'm going to turn it over to our special guest, our expert presenter here straight away, who's going to go through a very in-depth analysis of what we know so far with respect to the adapt and amend changes that are hitting, with a particular emphasis on the earned sick time. And so we're delighted to have a long-term relationship and support for the small business community from Warner, Norcross, and Judd. And one of the partners at Warner, Allyson Terpsma, is here, and she's an expert in labor law. And so I wanted to both introduce her and thank her for this excellent work and analysis. I think as we go through this, you're really gonna see the scope of the work that's happening, or the scope of the changes, but then also at the end of the presentation, we'll do some questions. We'll be gathering those up and looking for themes, especially if you want to comment as we go through, and have a bit of a discussion toward the end. And then also I'll share with you some of the reactions in terms of policy changes that we'll be seeking, some of the priorities that have risen up to the top of things that we think that need to be addressed straight away by the legislature. For some of these things you'll find are just not workable in their current form. Okay, so Allyson, thanks for joining us, and let me turn it over to you.
Thanks, Brian, and thanks to all of you for having me to speak on this topic today. It's obviously garnering a lot of interest, so happy to walk you through it and hopefully answer a lot of your initial questions about what to expect. So let me just advance my slides here. All right, so we're going to really briefly go through how we got here, what to expect, focus primarily on the paid sick leave law that's resulting, and then I'll walk you through some next steps that you should be doing to prepare for this new law. I don't want to spend too much time on this, but some of you might be having a little deja vu, because there was a time where we thought this law was going into effect earlier as well. So I just kind of want to remind you of that, so that you can rest assured that you're not just dreaming this up. So how we got here is that the Earned Sick Time Act and the Improved Workforce Opportunity Wage Act, which is essentially a minimum wage act, began as ballot initiatives way back in 2018. So what happened is basically supporters gathered a bunch of signatures in order to get these two measures on a ballot for voters to consider and vote on. The Board of Canvassers approved the initiative once they had enough signatures, and that gave the legislature at the time 40 days to either adopt the measure as written, or it would go on the ballot for voters to decide. What the issue at the time was that if the voters adopted the ballot measure, then the legislature could only amend it with a 75% supermajority vote. In contrast, what the legislature saw was that if if they adopted the measure, it would become law. They didn't need the governor's signature, and then it was silent on whether, how, or when the legislature could then amend. So what they basically presumed is it would only take a 50% majority, which is the case with most laws that are put into place. So the legislature went ahead, adopted both laws back in September of 2018. They were scheduled to take effect 90 days later, but before that could happen, the legislature went ahead and amended both laws, significantly reducing employee entitlements and in large part reducing the scope of the application as well for the Sick Time Act, such that small employers were immediately exempted from it. The governor signed both of the amended laws, but the advocacy groups, including those that prepared the ballot measures, challenged the constitutionality of this idea that you could both adopt and amend ballot initiatives within the same time period. So then we started going through the court system, and that's a long and winding road. But what you might remember is that 2 years ago, the Court of Claims, the first court to consider it, actually did rule the adopted amend procedure unconstitutional and said that means the ballot initiatives should go into effect as they were initially written, as if they were never amended. The court did 10 days later put into effect an order staying the judgment until February 19, 2023, just to give employers a chance to prepare to implement these. But there was a question, what about back pay? What about benefits that should have been earned during that time? How were employers supposed to address that? In the meantime, the decision of the Court of Claims was appealed. The Court of Appeals reversed and said adopt and amend was not prohibited expressly, and so therefore it was permitted. But then there was another appeal, right, this time to the Michigan Supreme Court. And in June of 2023, the Supreme Court did in fact grant review. So where are we now? Well, it took a whole year, but eventually last week, the Michigan Supreme Court reversed the Court of Appeals, basically agreed with the Court of Claims and voided the amended laws and reinstated both the Earned Sick Time Act and the Minimum Wage Act as they were initially adopted. The one silver lining, I guess, is that the court clarified that this was not retroactive. So employers aren't on the hook for the last 6 years while we've not been sure what to do, right? Due to this uncertainty. And the Michigan Supreme Court clarified that employers now have 205 days or until February 21st, 2025 to comply with these laws as they were originally adopted. So the good news is you have time. Don't panic. This is a typo here. Basically, the wages won't change and the sick time benefits won't change. That should say February 21st. I apologize for that. And there's no penalty or liability for employers who complied with the invalid amendments up until February 21st, right? Again, we were following what the legislature had told us to do at the time. All right. So some people have asked, could things change again, right? It's a valid question because we've been, flipping back and forth on this for 6 years. Well, it's the end of the line for appeals. The state could file a motion for rehearing, seems a bit unlikely. And also the current legislature could seek to amend either of these laws. So that's a possibility. Brian spoke about the fact that groups are kind of putting together proposals now for the legislature to consider. So it's possible, but for now, what we should be planning on is that come February 21st, these laws will go into effect as they were adopted. All right, so what does that mean, right? So that means we've got to prepare to comply with both the Earned Sick Time Act and this Minimum Wage Act as they were originally adopted. So we're going to go through those. and give you some general information about those. So I'm not going to spend too much time on the Minimum Wage Act because the Sick Time Act has a lot more detail that we need to cover. But basically, what the Minimum Wage Act does is there's an acceleration to the increase of the minimum wage. It increases minimum wages for tipped employees and eventually gets rid of the tip credit altogether. There's a provision about compensatory time in lieu of overtime, and I will address that briefly. And then there are some changes to wages for minors. I'm not going to get into that just because it's less applicable to most employers. All right, so obviously, when this law went into effect back in 2018, it had a wage increase schedule that spanned from 2019 to 2023. All of those dates are now in the past. So what the Supreme Court did is they actually created a new schedule. And we actually don't know exactly what the new minimum wages are going to be yet, because the Michigan Supreme Court has directed the state treasurer to use the inflation adjustment starting as of July 31st when this came out, and as the endpoint for the calculation of what the minimum wage should be. So basically looking at, okay, if it was supposed to be $10 back in 2019, what should it be now once we adjust for inflation starting February 21st, 2025. And notably, for those of you in the service industry or who use the tip credit will be 48% of minimum wage. So that means basically those tipped employees still have to be paid almost 50% of whatever that new minimum wage will be. And then the minimum wage is going to increase over the next 5 years, right? And the tip credit is also going to slowly dissipate. So that come February 21st, 2029, there will be an inflation adjusted minimum wage, and the tip credit will no longer exist. So that's what's going to happen for minimum wages.
Sarah, Allyson, if I could
Sure.
stop you there, just one real quick question. This is one of the few surprises in this decision that if it was to if they're going to go back to how it would have been, it seems like it would have been logical to say, well, it was supposed to hit, there was a predetermined schedule, it was supposed to hit $12. So it's $12 and then 2 years worth of inflation because that's what the original law called for. But that's not what they did. They created a new schedule and it's adding inflation to the old schedule on a step-by-step basis and then putting it in the future.
Yeah.
Any idea why go with this kind of complicated direction as opposed to trying to recreate what would have happened if the law went into effect back in 2018?
Yeah. I don't know. I was surprised by this plan as well, but I mean, I guess the idea was we got to come up with something, right? And this is what they selected, but there's not really a great explanation as to why this versus some other methodology.
When I run the numbers both ways for estimates, because the built-in increases are between 5.75 and 6.5%, it looks like it's actually, by doing it this way, it makes the end result higher, a little bit higher than if you did it the other way, because inflation compounds the built-in increases of 6 or so percent. So it looks like maybe it was just a way to get that minimum wage higher than if they just made it as though the law went into effect. So please continue on.
Yeah, it could be. At any rate, it's definitely going to be higher. A lot of employers were already paying significantly more than the minimum wage to a lot of employees just due to the labor shortage. But we'll see what the numbers come out to. It's definitely going to be something everyone needs to keep an eye on. I did mention briefly that the Minimum Wage Act does have a provision that permits voluntary agreements between employers and employees to use compensatory time in lieu of overtime. That's basically the idea that instead of paying an employee 1.5 times their wage for hours worked over 40, you can instead grant them an hour and a half of time off down the road. But I will specify and be clear on this. It's not permitted for private employers under the Federal Fair Labor Standards Act, which would presumably take precedent over the minimum wage law, right? Because you have to comply with both. So even though this law is out, or this provision is out there, I do not recommend that you take advantage of it, in large part because it seems to be precluded by the federal law on wage and hours. And to be honest, while the federal law permits this for public employers, usually the feedback I get is that it's an administrative hassle and not worth it. So just wanted to note that as well in case you see some information out there about it. All right, so now I want to jump into the paid sick leave law because that really has a lot of details to it that I want to make sure we have time to go through. All right, so couple of quick questions, right? Who's covered by this Earned Sick Time Act? How does it affect small employers? Does it include out-of-state employees, part-time employees? What about unionized employees? All great questions. So really, employer coverage is extremely broad, right? So basically, anyone or any entity who employs at least one individual is covered by it. So small employers are going to be affected by this. Now there was a list of ineligible employees under this law's precursor, right? The amended version of it. That is not the case here. It's an actually very broad definition of basically an employee's any individual engaged in service to the employer in the business of the employer. Now, most likely it doesn't apply to any employees who don't work here in Michigan, but even that's not clear, right? So it's a very broad definition of both employer and employee. It also affects any rehired employees. So to the extent you employ people from time to time, for example, if you employ someone who happens to be a student in town during the school year, and then they take the summer off and come back in the fall. Well, any employee who is rehired within 6 months gets to retain their unused paid sick time from their last bout of employment. Which is definitely a change from the past and something to keep in mind. All right, so what does the Sick Time Act say about leave accrual, carryover usage? What is it how much leave do they accrue and how much can they use and when can they use it? So the rule is that employees have to accrue 1 hour of paid sick time for every 30 hours worked. And there are no accrual limits, right? So somebody who works a lot of hours can just keep accruing. Front loading is likely permitted. That's the idea that rather than accrue it over time, we're just going to front load it at the beginning of the year so that they already have it. Presumably that's permitted because it's more generous than the accrual. But keep in mind, if you assume somebody's going to work a certain number of hours and use that assumption when front loading, if they actually work more hours than that, you'll have to then allow them to accrue additional time whenever they go over their expected hours, at least as it stands now, right? Maybe we'll get different guidance on that, but that's the letter of the law. All right, so also carryover, right? There are no carryover limits. So if somebody accrues a certain amount of paid leave during the course of the year and they don't use it, they get to carry it over to the next year. Same would be true if you front load it because again, we got to follow the letter of the law. But there are usage limits. So let me explain that. So for large employers, and large employers is, can include some pretty small employers actually, right? Because large employers are defined by this law to be anyone who employs 10 or more employees. They can limit usage to 72 hours of paid sick time per benefit year. Small employers, so those with fewer than 10 employees, can limit usage to 40 hours of paid sick time, but they also have to allow 32 hours of unpaid sick time in any given benefit year. Now, you do have flexibility with defining the benefit year. It can be any consecutive 12-month period. It could be the calendar year. It could be the employee's anniversary year. You could do it from February 21st to February 20th based on when this law goes into effect. You do have discretion with that. The other issue or thing to be aware of is, you have to allow employees to use sick time in the smallest increment that your payroll system allows, and it can't be greater than an hour, right? So if you track time by 1/10 of an hour, then you have to allow employees to use sick time for as little an increment as 1/10 of an hour. As you can imagine, I think this could get very messy for last minute tardies, right, in the morning. I wasn't feeling well. I need to use, 0.3 of my sick time because I'm late. I'm going to be late. So that's definitely an issue that, we didn't have before when there was an amendment. And then there's a 90-day waiting period for new hires. Just to be clear on that, people start accruing time right away, but you can make them wait 90 days before they get to use it. So I just want to take a pause here and talk about the kind of confusion that might come up because you can't limit accrual or carryover, but you can limit usage, right? So what that means is you can have people have a leave bank that just continues to grow and grow and grow and carry over, but you can limit them and say, hey, between these dates, right, of our benefit, the beginning date and the end date of our benefit year, you can only use either 72 or 40 hours of that paid time. That just becomes an administrative burden to check, right? Because now you've got a bank, and even if they have a bank, you have to remember, well, how much did they use? So I can limit that. So it's just going to be an extra step, which is unfortunate. But that's the way the statute is currently written, unless there are changes going forward.
So Allyson, I think that's just an important point. So like there's a certain amount that has to accrue every year. You must allow it to be carried over. It must carry over. But the amount that can be used, you can still limit to 72 hours if, depending on how many employees you have.
Yep.
And, but it does not require that you pay out unused.
Correct.
And
Correct.
so this is, it kind of, I interpret this as maybe it's just like a mistake. Like somebody, when they were drafting this proposal, this law back, they just did something that doesn't really make sense. But for employers, you don't have to pay this out, but you do have to let it continue to accrue, but you never have to grant more than 72 hours in a particular year. So it's an oddity in the law, but I just want to make sure to boil down that point, that because I saw a question come up, can you pay it out so it doesn't accrue? You have to let it accrue, but you never have to pay it out. Even if they leave employment, you don't have to pay out the unused sick time. It's just kind of an oddity that developed in this law as you really get into it.
Yeah. Yep. I think the mindset was they wanted, given that it's drafted as an accrual, they wanted to make sure that at the end of any, at the beginning of any new benefit year, employees would at least have the opportunity to have some sick time banked from the prior year that they could use immediately at the beginning of the benefit year. But obviously, given the usage amount, it would have made sense to allow employees to limit carryover, limit accrual to whatever they have to give in a benefit year. They just didn't include that provision in the statute. So that's the issue here. So I just wanted to make sure people were aware of it. All right, there are a lot of qualifying reasons for sick time. It's pretty broad, actually. So it's really any sort of illness or injury for not only the employee, but also their family member. Similarly, it's medical treatment, it's preventative medical care, There are also a lot of provisions related to being either either you or your family, be the employer, the employee's family member being a victim of domestic violence or sexual assault. There are provisions for the place of business being closed due to a public health emergency. You know, when this came out in 2018, I did think, oh, what's the likelihood of that? Fast forward 2 years and we have a pandemic, right? So these are all qualifying reasons under which employees have to be allowed to use their sick time, whatever they have available. The definition of family members is pretty broad as well. So it's any child, right? Biological, step, legal ward, child of domestic partner, etc. It's grandchildren and grandparents. It's parents, siblings. And then there's a catch-all, any other individual related by blood or affinity whose close association with the employee is equivalent to a family relationship. Pretty broad, not exactly sure how that's going to shake out. I could definitely imagine people are going to use it for live-in boyfriends, live-in girlfriends, maybe not. They're going to maybe try to use it for non-live-in boyfriends and girlfriends. I don't know, maybe roommates. It really depends, right? We just are going to have to wait and see how this shakes out. Okay, supporting documentation. One might think, okay, well, I have to let them use it for all these various qualifying reasons, but at least I should be able to ask for some sort of proof of what's going on. Well, there are pretty strict limits on that. So you can only ask for supporting documentation if the employee uses more than 3 consecutive days of paid sick time, right? So if an employee uses sick time Monday, Tuesday, Wednesday, can't ask for documentation. It's not until they use it on Thursday that you can ask for documentation. So that's a huge limitation on your ability to police this. But again, keep in mind, once they're out of their paid sick time or their paid and unpaid sick time, then they're out, right? They can't continue to use this excuse. The employer actually has to pay any out-of-pocket costs incurred by the employee in securing the documentation, right? So if you do require a doctor's note and they go to the doctor and they have to pay a copay, then you have to pay that copay for them. And you can't require that the documentation explain the details of the situation, right? So a doctor's note can be very plain vanilla. You can't understand the nature of the illness, details of the violence, etc.
Now, Allyson, you said doctor's note, but
Yeah.
But in reading the statute, I don't think it actually requires that it be a doctor. Is that?
Yeah, any healthcare provider, right? So somebody says I need sick time, you can at some point require some sort of evidence that they were actually sick, because they went to a doctor, or maybe they're getting care, whatever the case may be. But it's very limited. It's not like you can say this is insufficient. Like if they basically give you anything that would seem to support it, that's about all you can require. Employers are going to have some notice requirements, going to have to display posters in the workplace and provide written notice of this law at the time of hire. The Labor and Economic Opportunity Department for the state is going to translate those notices and posters into other language. So to the extent you have a workforce where at least 10% speaks one of those languages, you have to use those notice and posters as well. Record keeping. So you have to retain records of paid time accrued and paid time used for at least 3 years. And notably, the Sick Time Act actually creates a rebuttable presumption that if you don't have the records, the presumption is you did not comply with and instead violated the Sick Time Act. Now you can ultimately with any presumption, you can ultimately defend against that and flip it back your way. But again, that's going to be hard to do if you don't have the records, right? So certainly want to make sure you're keeping records. And that's why it gets a little tricky to, have both records of that accrued bank growing and growing and growing, but then also what the usage is over time. So that's definitely going to be a bit of an onerous requirement to keep in mind. And in terms of enforcement, employees have a couple of different avenues to go if they feel like their employer is violating the Sick Time Act. They can either file a claim with the state agency in charge of enforcing it. They could otherwise file a civil action in court, and this the statute of limitations is 3 years, right? Which is a pretty long time. Again, that kind of relates though to why you need to keep the records for at least 3 years, because that's how long they have to go and file a claim. All right. There are also rules and specific provisions in the Sick Time Act prohibiting retaliation. And again, there's another rebuttable presumption created by the act. So there is a rebuttable presumption of retaliation if an employer takes adverse personnel action against any employee within 90 days after that person either files a complaint with the state or in court alleging a violation, informs anyone about their employer's alleged violation, cooperates in any sort of investigation or prosecution of a violation, opposes any policy, practice, or act that's prohibited by the law, or informs any person of their rights. So, for example, you might have an employee come in and say, hey, I think your paid time policy doesn't completely comply with the law. Don't I need this? And they might not be right? You might say, no, it only requires that yes, I have to allow you to accrue it, but you only get to use, 72 hours during the benefit year. Okay, they go back to work, and then, they engage in some performance issue or misconduct, and you take a disciplinary action. Well, if they're 90 days apart, there's a rebuttable presumption that that's actually a retaliatory discipline. Now, you can again defend against it. You can flip it back the other way, but it's going to be really important that you have extremely good documentation of why you're taking that disciplinary action. Because again, there's going to be this presumption against you. And so you're going to have to prove why it was a legitimate discipline for misconduct, for poor performance, and that had nothing to do with this protected activity as defined by the Earned Sick Time Act. The other thing to note is the law specifically says you can't have your attendance policy penalize an employee in any way for using sick time. So that's where I mentioned, if you have a situation where you point people for being tardy to work, well, while they still have sick time available for them to use, if they use sick time to kind of cover for those tardies, you're going to be you're going to have to kind of, unfortunately, let them do that, because it specifically says you can't discipline them for using their sick time. And because you can't ask for documentation, were you really sick and that's why you were a half an hour late this morning? Or did you just sleep in, right? Like there's no documentation you can ask for that. So that's really going to make for some operational challenges going forward, unfortunately.
And I think this would be a good time to remind our audience that while we share information with you about the reality of how difficult management is going to be under this act, do not interpret that as our support for any of the things in this act. That this, we want to share with you so you're prepared for it. But we are working overtime on prioritizing changes that need to be made so that you can run your business. I can feel like as an employer, we're an employer too. And I can feel just kind of like in every room I'm in where employers learn what's really in this act and how difficult management will be under the requirements of it. You can kind of, feel the anxiety and the blood pressure rising that this is going to be so difficult. And yes, it is going to be difficult. So we want to make sure you're informed on what it says, but that doesn't mean we're not working hard to get changes made. All right, Allyson, please.
Yeah, no, absolutely. I feel everybody's concerns, right? Like these are challenging issues for even large employers, right? So small employers, it's just really difficult. All All right, as Brian mentioned, a few final details, but there's no payout for unused paid sick leave at year end or termination. So if someone doesn't use their sick time, you don't have to pay it out. You don't pay it out at year end or at termination. While at year end, it just carries over. At termination, it goes away unless, of course, you rehire them within 6 months. But in general, there's no payout. The employer does not have to count the use of paid time off or paid sick time as hours worked, right? So when you're tracking time, and in order to determine whether they've worked 40 hours and if they've worked more, if they're entitled to overtime, this time that they use does not count as hours worked for that purpose. And to the extent you do have other types of paid time, right? So a lot of employers do have like one bucket of paid time off that people can use for vacation, personal time, or sick time. That can count towards these entitlements under the Sick Time Act, as long as people can use it under all the same terms and conditions, right? With respect to notice, et cetera. So that's an important distinction.
Yeah, and if I could just develop that a little bit longer. So technically you can use general leave banks, but only if you meet all the requirements of this act. And so for a lot of employers, you're going to find, no, you can't use, in practicality, you can't use your regular leave banks, because how can you say how can you create your vacation time and say vacation time requires no approval or pre-notice in order to use it? There's certain requirements that of this act that wouldn't naturally apply to other types of leave. So you'd have to be prepared to have a general leave bank that didn't require previous notice or approval of supervisors in order to take that time. So I think a common response to a lot of employers is that they're probably going to separate out their leave banks now in order to comply with this act, but not let the requirements of this act kind of bleed into the rest of the leave that you offer to employees. Okay, Allyson.
Yeah, Brian, that's exactly right. That's really what this slide is about, right? So, okay, if you do have an existing PTO policy, can you use it, right? Are you covered? So again, if you have a current PTO policy, people can use it, and it has at least 72 hours. Is this sufficient? I mean, in theory, right? Like it's still, you're still giving out the same amount of time, but you now have all these additional requirements with respect to accrual and documentation. And you can't require, like if you currently require, hey, in general for vacation, I need 2 weeks notice, right? People don't know if they're going to be sick 2 weeks in advance. So that's not going to work. So you might be able to just take the policy you have now and make changes to it and then be covered. But to Brian's point, this other question is, well, what if we don't want to change all those rules for all of our PTO? Can we reduce it by the number of hours required under the earned sick time and classify those as ESTA only time, right? And people can only use it for the sick time. And yeah, you can absolutely do that. And I think a lot of employers, whereas the trend in the past has been to move towards one combined bank to give employees maximum flexibility, I think the trend going forward may be that we start separating it out again so that, to the extent we give people more time off than what is required under the Earned Sick Time Act, then for that additional time, we can at least require greater advance notice, pre-approval, et cetera. Whereas with the Sick Time Act, we're more limited to a certain number of hours when they can just call at the last minute, right? Because they're sick. So I definitely, and use a very small portion of it at a time, right? As opposed to a half or full day or something like that. So definitely see that happening as well. Now, the other thing to think about is not only what you can do, but also how it's going to affect employee morale is right? Because some employees are not going to like the idea that they no longer have vacation time. They only have this sick time. And how are you going to kind of communicate that as well? So that's going to be part of the challenge. Really briefly, I don't know that any of you have unions. If you do, just know that your union contract, you know, remains in effect, even as of the expiration date. It's only, as of any stated expiration date after February 2025, that you're going to then have to comply with ESTA for your sick, for your unionized employees. At that point, you know, leading up to that expiration date, you're going to want to come up with a plan, how you want to comply, communicate it to the union, and be prepared to bargain over it. And hopefully you can reach an agreement. Otherwise, be prepared to press to impasse as needed. All right, so we've covered a lot of the details. Hopefully your mind isn't swimming too much, but I want to break down some of the things you should be doing now. Again, we've got time to prepare, but let's go ahead and start preparing for February 21st so that we have a plan that we can implement in plenty of time, to make sure we're in compliance. So first, I would say, look at your wage scales, right? Once we have a better sense of what the actual numbers are going to be for the new minimum wages, are we in compliance with that? To the extent we have tipped workers, are we going to have to make changes to the tip credit? And start thinking about that. Same with your time off policies, right? We talked about that a little bit right now. What's currently in your policies? How do you want to change them? You know, you have options. You don't have to just take what you have and make it ESTA compliant. You can totally, if you have a combined bank now, you can move to a separate sick time policy. You know, so take your time and think about how you want to implement these rules. As you're doing that, you're going to want to think about how the new changes are going to have a financial or operational impact, right? They may very well increase your labor costs. So you're going to want to think about how you're going to deal with that and account for that and address it. What about operationally, right? Potentially employees are going to have more paid time off, easier to use paid time off. How is that going to affect you from a staffing standpoint? Are you going to need to hire more employees? Are you going to want to contract with a temp agency in order to call in for temp employees on a regular basis? Going to have to think about those attendance policies, right? If we can't hold people accountable, you probably have to make some changes to that as well, recognizing the limits. Again, unless things change, hopefully they will, but it's something to start thinking about. Timing, what benefit year are you going to want to use? Do you want everybody on a calendar year? Do you want to start, if you haven't been providing paid leave previously, do you just want to start February 21st because that's when the law goes into effect? All right, coordinating benefits, right? This kind of goes back to what we talked about. Do you want to separate, if you currently have a PTO policy, do you want to separate out sick time from it? To the extent you offer short-term disability benefits, a lot of times there's a waiting period that is intended to be covered with sick time, right? So if you previously provided, you know, a week of sick time, and now you have to provide 72 hours, so that's almost 2 weeks instead. Do you want to extend that waiting period for your short-term disability benefits to account for that and kind of help hopefully offset that a little bit? Communication is going to be really important, right? And you're going to want to communicate, think about how you're going to communicate your changes to a number of different people. So a lot of employees are going to read the headlines and think, wow, I just get 72 additional hours of paid time off every year come February 21st. Well, for most employees, that's not going to be the case, right? Because you know, for some it might, for some they may not have had any paid time off before, but for others they maybe already did have paid time off, and you're going to figure out a way to just allocate that time now to the sick time law compliance. But you're going to want to think about how you're going to communicate, how you're going to explain this to employees so they don't think come February 21st, they just have all this time to use. You're going to want to explain the accrual policy and all of that. What other stakeholders do you need to talk to? Well, you might have some supervisors and managers who are going to need to understand how this may affect their ability to manage attendance, and talk through that. We talked about you working with a temp agency to help you with any staffing shortfalls. Well, you're going to want to make sure that staffing agency is also complying with ESTA and that they will indemnify you if there's any sort of claim to the contrary, right? So you're going to want to make sure you're covered on that front as well. We talked about sort of the oddity where where employees have to be allowed to accrue and carry over basically unlimited paid time off, but you only have to but you can limit how much of that they can use in any benefit year. Well, not every system is going to be built to track that, right? Because a lot of times these these HR systems, time system, payroll systems have a bank, and if you have time in the bank, you get to use it, right? So you're going to want to make sure that whatever system you're using is going to be able to accurately limit usage, even if the bank is greater than what that usage limit is. Talk to your third-party payroll provider, leave administrator, to the extent you use one of those, to make sure that they are prepared for this as well. Also, to the extent you use any of these administrators, double check your contract for what happens with your records at the termination of that contract, right? Because again, now we have to be able to access those records for up to 3 years. So to the extent that your contract and you switch vendors and your contract ends, can you get those records at the time of termination? Can you get them later? You'll want to look into that as well. For those of you who are wondering, okay, well, I've never had sick time before, we do offer at Warner model policies for $400. We have them for both, whether you're a large employer with 10 or more employees or one with fewer than that. Can reach out to, if you work with a Warner attorney, you can reach out to them, my colleague Liz Burnson, or me, if you're interested in that as well. So with that, I've reached the end of my long presentation, but we can open it up.
All right, lots of questions, as you might imagine. So let's see how many we can get through in the time that we have left here today. So you covered this. Does sick time carry over? There was a question: can you pay out at the end of a calendar year and not carry it over? But I think it's probably important to point out that you never, even if somebody's employment is terminated, you never have to pay it out. So this idea of payout is not something that that really would ever come up, but you must let them carry it over, even if they can't use it.
Yeah, that's exactly right. And there's no, basically the law is silent as to whether you can pay it out at the end of the year rather than allow it to carry over. But I don't see an upside to that because you can limit usage, right? So, cost wise, it will be cheaper for you to just limit usage as opposed to pay out in lieu of carrying over. Plus, we don't even know if the Sick Time Act would actually permit for that because it doesn't address that option.
So if I've got an employee that is either fully commissioned or part on commission, and they use sick time, it's going to require going back and calculating what their kind of hypothetical hourly rate was in the previous time period. Maybe touch a little on that.
Yeah, that's really not addressed. So that's going to be something that is going to take some digging for employers to figure out how to do that. And it's not going to be particularly straightforward either. Yeah, it's going to be a challenge, right? Because in theory, a commission-only employee can always take as much time off as they want, right? It's just, but how do you pay it? So that is going to be something that is going to take some time to figure out.
There's naturally a bunch of questions that come out. What about I've got an employee, they're only going to be here for 2 weeks, really a part-time employee,
Yeah.
or they only work 3 hours a week, or they're only seasonal, or there's all these like, it's only this, it's only that, it's only that. But this is so broad. If you have somebody on your payroll for any period of time, the accrual kicks in, even if you don't have to allow them to take sick time for 90 days after employment begins. You must accrue sick time starting straight away, even if they're short-term, long-term, part-time, full-time. It pretty much covers everything. Is that true?
That is true. I think the upside is for those short-term employees, they're only employed 2 weeks. Well, if you have a 90-day waiting period, which you're permitted to have, they're never going to be able to use it, but you still have to accrue it, right? So just plan on, this is going to be an exercise in record keeping. That's probably going to be one major hassle with this. So again, you have to have them accrue it, but you may never have to let them use it, right? But on the flip side, if they work for 2 weeks, leave, come back 5 months later, whatever they accrued, they get to have again, right? And once they finish their 90-day period, that's going to count. What's very interesting is, there are going to be all these like, there could be random situations where you don't know, right? So somebody could work 2 weeks, gone for 5 months, to come back. And what the act says is you have to basically give them all their previously accrued time and let them use it upon reinstatement. Well, what about the 90-day waiting period, right? Like, does that kick back in? And it's just not clear, right? So there are going to be lots of these unclear questions that we're going to have to think about when they arise. But in general, the upside for short-term employees and part-time employees is that if they're short enough, they'll never use it. And for part-time employees, it's going to take them a lot longer to accrue the time, right? So if you have someone who works a half day a week, they're only working 4 days a week, or excuse me, 4 hours a week. Well, it's going to take them many weeks in order to earn just 1 hour of sick time, right? Because the accrual rate is 1 hour for every 30 hours work. So that's going to take them over 7 weeks before they get that 1 hour of sick time. But then once they get it, and once they hit their 90 days, they can in fact use it. So there are no exclusions, but keep in mind for those part-time employees, it's going to take them longer in order to earn any of that sick time as well.
How about on salaried employees? Several questions about salaried employees. Employers they're not keeping track of hours for how the accruals work. So will they need to start tracking hours for salaried employees?
So let me see if I can find this. Okay, so an employee who is exempt, they are assumed to work 40 hours every work week unless their normal work week is less than 40 hours, in which case you can use that normal work week, right? So if you have a salaried employee and you really only expect them to work 30 hours per week, well, then you can use 30 hours instead. But in general, you don't have to track their time. But if they're full-time, you would do, 40 hours for each week of work. And so they're going to accrue, 1 1/3 hour of sick time every week. And then if you have someone who works less than that, then you can use that lower number for their normal work week.
And so just to, I think a lot of times our people kind of play out worst case scenarios. So in that circumstance, yeah, salary, you only expect to work 40 hours a week. But somebody later on says, yeah, but there's this new project came on. I've been working 50 hours a week and you haven't done it right. And then the employer doesn't have records and there's a dispute or a complaint. Is that a risk for employers?
According to the language, no, it shouldn't be, because again, it says any exempt employees, they're assumed to work 40 hours unless their normal work week is less than 40 hours. And then you can use the normal work week. So it doesn't say if their normal work week is more than 40 hours, you have to use that. So they do kind of set it as a 40-hour max for exempted.
So it's but an important distinction: exempt versus not exempt, not salaried versus non-salaried. So
Correct.
Like we at SBAM, all our positions are salaried, but they're not all exempt. Okay.
Right,
All
right.
right.
Yeah. So if you have anyone who's salaried, but then when they work more than 40 hours a week, you pay them overtime because they're not, you don't treat them as exempt, or they don't qualify for the, exemption based on their duties, then you're going to want to similarly use their hours to track their sick time as opposed to that 40-hour week because they're not exempt.
And so if there's an out-of-state employer that is employing people here in Michigan, everybody they employ in Michigan is going to be subject to this act. Is that correct?
Yeah, that's how I would interpret it. Typically, what matters is if you're doing business in Michigan by employing people here, then the employees get the benefit of all of the employment laws.
All right. And you'd mentioned the employer picking up costs if they require documentation. So you can only require documentation after 3 consecutive days, not 3 days, but 3 consecutive days of sick time. You can require documentation. And you said the employer must cover any out-of-pocket expenses. So it would include a copay, for example, on a health plan.
Yeah, that's right. Yeah, so it's definitely a major burden shift to say, hey, if you want documentation, you've got to pay for it.
And then what if an employee is gone for 3 consecutive days and doesn't provide documentation? At that point, the employer would be free to take disciplinary action?
Yeah, so I don't know if it's that clear on it. And it's not probably clear, like, can you discipline them for the whole 4-day absence or only the last, the fourth day where they didn't provide the documentation? These are things that, the statute itself doesn't get into that level of detail. So that's going to be something that we're going to have to interpret the best we can until there's either more guidance, either through, the state agency putting out guidance, or frankly court cases, right? That interpret the law over time. So we're going to have to be figuring it out in general, right? There's going to be two sides to this, right? So operationally, you want to be able to be as stringent as possible so that you can run your business. But there's legal risks to that, right? So a lot of employers don't want to be the test case for figuring this out either. So it's going to be a bit of a balancing act while we figure this out.
Allyson, in that previous question, when we talked about exempt versus non-exempt, I think it may have been a little bit confusing for some of the folks that are watching because you can't just exempt people from this act. Everybody's covered under the act. When we talk about whether you have to accrue or not, an exempt employee and non-exempt employee is talking about exempt from overtime, has to do with management responsibilities, and that's a legal definition. Could you give just a quick little primer on exempt versus non-exempt employees as a general status that is not this act, it's not exempt from this act or not exempt, but it's just kind of the bigger question.
Yeah. I mean, the one thing is like no employees are exempt from the Sick Time Act. So it's definitely, we're not speaking in respect to that. So, employment lawyers often use exempt without being as clear as we should be. So, I mentioned briefly the Federal Fair Labor Standards Act when I was talking about Michigan's Minimum Wage Act. And that law applies to all employers. And it basically says in general, you have to comply with the federal minimum wage, which is a lot less than Michigan's minimum wage. So by complying with Michigan's minimum wage, you're covered on that front. And you have to pay overtime. So 1.5 times an employee's regular rate of pay for any hours they work over 40 in a work week. But there are exemptions from these requirements. So the most common exemptions we think of are kind of for certain professionals, certain managers, executives, etc. And for those folks who satisfy basically in general 2 tests. So not number one, they have to be paid a certain salary threshold, above a certain salary threshold on a weekly basis. And that's actually in flux right now too. If you haven't heard, we just had a salary threshold increase as of July 1st, and it's going up pretty significantly again in January, again, unless there's court intervention. But you have to satisfy that salary threshold test, and the employee has to have a primary duty that satisfies certain legal definitions for administrative employees, professional employees, management employees, etc. And if both of those are satisfied, then all you have to do is pay that employee their salary for every week in which any work is performed. And you don't have to track their hours, you don't have to pay them overtime, you're covered. And those are what we call exempt employees. And so because for exempt employees, employers don't track time, the question for the Sick Time Act came up. Well, how do we allow them to accrue time when we don't track their hours? And the answer that the Sick Time Act gave us was you can assume they work 40 hours per week. If you have any exempt employees who work fewer than 40 hours a week, right? They're only expected to be there 4 days a week, for example. You can go ahead and use whatever their normal work week is in order to accrue their sick time as they work.
Excellent, Allyson. Thank you so much for your expertise. We are here at the bottom of the hour, and so our time is up, but I want to remind everybody that we do have a resource page that we are constantly updating as we get more information. We're meeting with the State Department. We're meeting with legislators. We're putting priority lists of changes that we're asking for together. And so I would encourage you to visit sbam.org regularly for what's happening. And we are going to call on you, by the way, later on to advocate for some changes when we have some things that we're going to put forward, you know, half a dozen at least changes that we will be asking the legislature to make. We will let you know what those are and encourage you to contact your legislator to support making this more workable for employees going forward. As usual, Warner performs with expertise and excellence. Allyson, I appreciate you coming on and sharing your knowledge with our team. Thanks so much.
Thanks, Al.